Hi, everybody. This is Steve Maggi from SMA Law Firm. Welcome to Building the Bridge. My guest today is Elliot Alderman, an IP and tech attorney based in DC. How are you, Elliot? Thanks for joining us.
Hi, Steve. I'm glad to be here. Doing well.
So we both work with a lot of international clients, and perhaps some of them don't know the most basic thing, which is what is intellectual property? Can you give us just a brief idea of what that means?
Sure. I think a lot of clients don't know what intellectual property is, so it's not just international, but essentially, intellectual property is copyright, trademark, and patent. Patent tends to be people who are tech trained in a specific narrow area. I don't really do patent work. I have a network of people that I work with. If I have a tech transfer agreement, for example, where there's a question about scope of protection or something, I would involve a patent lawyer. They tend to be niche experts where there are some who do life science patents. I have some that I will call them with something and they only do a really small area. Predominantly then intellectual property is copyright and trademark. People typically think of copyright as being sexy things like entertainment. So it's visual artists and music and performers and stuff like that, writers. Copyright also protects software. And that's where, for me, the bridge is between IP and technology, that I end up doing a lot of work with technology companies. I tend to also work with successful creatives because there's a lot of people who can't really make a living doing it, and I can't really help them, or a lawyer in my position can't really help them unless they're in the business of doing it, because unless they have regular need for advice and licensing agreements and stuff like that, there isn't really much that I or someone else in my position can help them with. Trademarks tend to be broader than copyrights in terms of industries. I think people typically think of copyright as being in the entertainment industries, and as I just said, software, computer stuff. Trademark is essentially any product or service, so it cuts across industries. It's for a logo, a word, a sound, a smell, and that really is for any company or individual that has a product or service where you want to have a source indicator, which is how you show that you are the source of this good and you can ensure quality.
Okay. If you're a foreign national and you have a company, let's say overseas, and you have various copyrights and trademarks, let's say in Taiwan or in Australia or somewhere else, you want to launch a US subsidiary to expand your brand or to bring your services to the US. Are you already covered?
It really depends. I do a lot of work for trademark internationally, where trademarks are not typically extraterritorial, which means that they're limited to the country where you file the mark. And what you would do would be you'd have a global brand strategy. So you'd think about markets that you're going to get into, and then you would pre-clear a brand, which is really necessary because if you have a global brand and you get into a country where someone else has prior use and superior rights, then your choice is that you have to rebrand or not do it. And usually rebranding is the easier course, but it's always better if you have a global strategy for your brand so that you have the unitary brand as opposed to transacting business in different countries under different names. Okay. Copyright is easier because there's a multilateral treaty called the Berne Convention. And for the most part under Berne, if you register, you have protection. But if you, depending upon licensing agreements, you may need to register in the US, and definitely if you're suing for statutory damages, you need to have a registration. Sometimes if you set up a US subsidiary, depending upon how you license, like if they have rights to it and they're an entity in the US, then you would need to register your copyright to enforce it. But generally, it makes sense to register in any event, because even if you could protect it under Berne, statutory damages are usually the way that you protect copyright. So it's worth the process of doing that.
What are some examples of cases you've seen where the kinds of products or services that somebody might provide overseas, or a creative perhaps, that they just assume that they don't need a trademark or a copyright?
I'm not sure I understand the question.
So what are, like, overall, what are some general things that you see where people come to you and say, oh, I didn't know that I needed that, and it's something that you've seen on a recurring basis, a specific fact pattern?
I have found that with copyrights particularly, what happens is that intellectual property generally is very detailed and fact specific, and you need to do things from the beginning, because if what turns out to be hundreds of dollars maybe for registrations quickly becomes thousands or tens of thousands if you have litigation, or you don't have rights to something because you didn't clear it adequately, then you have a larger work. Like I do a lot of work with complex things like documentary films, where essentially it's like a jigsaw puzzle. And if you don't have rights to all the elements, you either can stop doing it because somebody gets an injunction, or you're going after the fact and trying with no leverage to negotiate rights, where if you had done it up front and cleared them, it wouldn't be a problem. Another issue that often comes up with copyright particularly is that you need a written agreement with somebody who's not an employee. And typically for startups or for foreign companies that are coming into the market, if they don't have the agreements that they need, like there are standard things that you should be doing, like setting up an entity and having work for hire agreements and non-disclosure agreements and independent contractor licensing agreements.
Right.
If it isn't an employee and you don't transfer rights, you have a situation, and this has happened several times with me, where I often get referrals from other firms where there's a mess down the road because these things weren't done, the T's weren't crossed and the I's weren't dotted from the beginning. So if you have that situation where the rights aren't transferred, then downstream you have people who are building on the work. And this happens often with software, where it's very, very complicated, and someone who's an independent contractor hasn't signed rights to the commissioning party, and then someone does something that is derivative from that, then it becomes so complicated because you can't track who owns what, that you get to the point where it's either impossible or so cost ineffective to do it that all you should have done up front was to have done, the correct agreements.
Yeah.
And I guess with the trademarks, what I've seen is one of the worst things you can do with the trademark is to spend a lot of money on marketing to find out that you need to rebrand because you didn't do a search, or you didn't anticipate that you were going into another country or another region. And you have to, like I said before, you have to either change your branding or do something to avoid someone who has a prior mark.
What I've seen across the board in these interviews that I do with other professionals like you that work with foreign nationals and companies that are expanding is the concept of prevention and planning seems to come all the time, right?
Yeah.
So if someone has some foresight and they want to take the preventative measures they need and they want to do their due diligence, how do they get in touch with you to start that process?
My email, probably the easiest way to reach me is either to call me 202-596-5682, or my email is my name, ELLIOTT, at the Content Lawyer. Another situation, which maybe you were asking this as a question, another thing to factor in beyond the compliance and clearance issue is that there are cultural issues with certain words where they don't fit into another culture. And I think that one of a famous trademark situation was with Nova, Chevy Nova, where I guess in the Spanish market, it means something like don't go. And
Means doesn't go or doesn't work. Nova means it doesn't work.
yeah, which is not a good brand to have going into a market. So beyond availability, the trademarks are very much a contextual, cultural evaluation. So it's something to think about beyond whether it's available when you do the trademark search, that maybe this is not a brand that you want to have in this culture. It doesn't reflect well on the owner of the trademark.
Yeah, it makes you look bad when you haven't done the thinking ahead of time.
Yeah.
Well, thank you so much for your time and for your knowledge, Elliot. Appreciate it.
Thank you, Steve. It was good to see you.